Welcome to the First Court of Appeals. We have one case on this afternoon's docket. We have FMC Technologies Incorporated versus Richard Murphy and Dril-Quip Inc. 01-21-00-455 CV. May we have appearances, please?
Your Honor, Tom Wright and Joe Ahmed for FMC.
Thank you.
Your Honor, Mason Readers Jones for Appalachian Dril-Quip Inc. and Richard Murphy and William Council Table Trucks.
Thank you. Welcome. I believe, did you notice this for 20 minutes per side for argument? Or? Yes. Okay. And the appellant, has the appellant reserved time for rebuttal?
Your Honor, we will reserve 5 minutes for rebuttal.
Perfect. All right, we are ready to proceed.
Justice Landau, may it please the court. It's difficult to exaggerate the amount of confidential engineering drawings, presentations, data that Mr. Murphy took from FMC when he left and went over to Dril-Quip.
Mr. Wright, I'm glad that's what you started with, because that is actually where we were hoping you would start. And so I'm going to ask you probably, pretty basic but critical question for us, and that is, what exactly is the evidence that would be the preponderance of the evidence that we would be able to rely on to actually reverse this jury verdict?
Yes.
As you're asking, because that's a pretty big ask.
Right, and it's, it's the great weight. So there's no doubt that both of these companies were working on a very important piece of equipment to help produce oil and gas out of the subsea and to try to prevent, the spills and all that kind of stuff. So the evidence, of course, is that he took thousands of drawings. I've got some here, 7A and 7B, I printed out. I'm hoping that since these were sent to the court under seal, that the court's actually been able to open them. But they're detailed schematics and drawings of FMC's product. And there's no doubt that it was misappropriated. There's no doubt that it was taken. There's really no doubt that there was a lot of data. And what the trial focused on was this reasonable measures and the evidence that came in from Mr. Pooley.
But if we don't even, let's just pretend that we don't even look at Mr. Pooley. If we're just looking at element B, I mean, can you speak to just what would be the evidence that you would point us to? I mean, obviously we've read everything. I'm not asking you to regurgitate your brief.
No, I understand.
But I do. I mean, that we do have, right? We could go forward. We could go forward. With just looking at one of the. I mean, right? It doesn't require that we.
Right. You just need to find one of these errors to reverse on. And frankly, I think the easier ones are Mr. Pooley and the charge error. Because in order to look at all the evidence and conclude that the jury's no finding was against the great weight and preponderance of the evidence, which is our burden, you would have to do a very detailed record review. And because of the broad form way in which the question was submitted, and nobody objected to that, but we don't know. And they've made a point that, well, we don't know if it lacked value, or we don't know if it had been published, or we don't know if there was insufficient measures to keep it a secret. So they've got a point about that. So we would have to overcome all of those to get it reversed on the great weight preponderance of the evidence.
So Mr. Wright,
yes.
I think I understand that you're saying that the other two issues, the jury charge error and Mr. Pooley's testimony, are sort of easier to analyze, but I think the question that we have is the more difficult one, which is specifically the great weight of the evidence to show that there were trade secrets, not so much that they were taken. So I think you started by saying there's no dispute that a lot of information was taken, but what in that information actually constituted trade secrets specifically?
Yes, well, it's the drawings 7A and 7B, 8A and 8B. We've listed others in our brief that I may not have all the numbers down, but he took PowerPoint presentations, hundreds of pages of information that he took from FMC, and they ended up in Dril-Quip's presentations. And so, you know, I would say you can't really get to that unless you're going to decide whether to give any weight to Mr. Pooley's evidence. I mean, I think it ought to be reversed on that, but at the least you could say, well, Mr. Pooley shouldn't have been allowed to testify, so we're going to take out all of his evidence about reasonable measures, which was, you know, his opining on the law, and then analyze the weight of the evidence.
What about I'm sorry, go ahead.
Oh, I just had a thought, since you're talking about the opining on the law,
Yes.
can you identify for me by record page number where he opined about the law? Gave a legal opinion as opposed to a factual expert opinion?
Yes, and if you have our bench book, if you look at tab C, we have outlined there all of the ways in which he gave legal opinions, and we've got the record sites there, and those sites were
Were those accompanied by objections
well,
in tab C?
we over-objected to Mr. Pooley. We objected at the very beginning. We moved to exclude, okay? It wasn't just a motion in limine. We moved to exclude all of his testimony about the law. Then, in the middle of his testimony, we filed another written objection because he went one day and then the next day. We filed another written motion to exclude and to strike his testimony, which was heard and which was denied. And yes, you know, our brief sets out the various ways in which we objected to that. And
Was the over-objection about the legal opinions that he was expected to deliver?
well, it's not only legal opinions, it's incorrect legal opinions. So the Fleming case, for example, involved a law professor that gave a legal opinion that the DRs could be used to show breach of fiduciary duty of a lawyer. Well, that's not only a legal opinion, it's an incorrect legal opinion. And that's what Pooley did, if you, in our handout, the very first one. He says the company should adopt the same approach to protect trade secrets. The standard's always the same. The law says differently, and Mr. Pooley says differently. He says that you ought to have an inventory of all of your trade secrets, just like you were making an inventory in what's in your pantry, he said to the jury. The case law says otherwise, and Mr. Pooley, and it's in our chart, said that's a fool's errand. You don't have to, in his book, he said you don't have to make an inventory like you would. So and those are just two examples. Over and over again, he, without regard to this particular industry, because he knows nothing about engineering, knows nothing about oil and gas law. He knows nothing about the fact that Mr. Murphy was the one who was developing these engineering drawings and did not want to address how can we keep away from the man who's developing them the things he's developing. It made no sense, but he touted his appointment by the White House. He touted all of his credentials, just like the expert did in the Fleming case. And if this court says that what Mr. Pooley did was okay, you'll be the first court in this state to ever say that. We've cited on page 10 of our brief 8 or 10 cases where this has been disallowed. Now, I'm not talking about attorney's fees cases. I'm not talking about setting the standard for, you know, reasonable care in a malpractice case. This would be the first case in which a lawyer, a practicing lawyer, whose only expertise is being a lawyer, because he's got no engineering degree, no science degree.
Right, but a person can be qualified as an expert based on their experience, even if their entire background isn't. Just because his initial background was in trade secret law doesn't mean, I mean, how can that also mean all of a sudden that he can never be an expert, even though now he's mostly consulting in the area that he was previously practicing in?
Well, he's not mostly consulting, Your Honor. He's mostly still being a lawyer, and his consulting is mostly doing this kind of expert witness consulting as a lawyer to tell them, like what they did in this case, don't focus on what Mr. Murphy did, you're going to lose. Focus on the reasonable measures. And so, you know, his position with the UN organization that had something to do with patents, those are patents that companies file with this UN organization. It has nothing to do, that organization wasn't developing any science.
But he testified that in that position, he was responsible for managing employees and managing systems to keep patent applications and the information in them secret or confidential.
Right, yes. But, it's really not so much his qualifications as what his testimony was, testifying about things that are not the law as if they were the law, and trying to make everybody believe that he was the lawgiver in the court when it should have been the trial judge.
So hypothetical. So if Mr. Pooley was not a lawyer, but all of his credentials were the same and his testimony was the same, would that change this for you?
Well, I think he would not have tried to give an explanation of what the law is. But we had an expert, really a rebuttal, even though we had to put him on first because of Judge Sandal's ruling, that was a, reasonable measures kind of guy. But he had a science degree, he had a IT degree, but he wasn't up there trying to tell people what the law was. Mr. Pooley was, and that's what takes his testimony out of the realm of permissible testimony. Excuse me. Sorry, I've been fighting this all week and I didn't want to ask for postponement. I'd like to talk a minute about the charge. After the charge was read, the trial judge amended it. The Mopak case out of the Texas Supreme Court said that that's an error and that the harm was obvious. Now, in that case, there was a slight difference. Counsel had started arguing before the error was found. But the court referred back to the rule that requires the charge to be given to the lawyers and the objections to be made before the charge is read to the jury. So what happened here was the judge sent out a charge overnight. The sentence was missing. The sentence that has I have Googled that sentence that he added. Not Googled, I run it through Westlaw. The only hits are the briefs in this case. There is no other case that says anything like that. That is not the law, and it was an error to give it, and it was more of an error to give it at the time he gave it and to tell the jury, I have amended the jury charge. And then counsel for Drillquip gets up and says, look, the judge amended the charge. This is very important. We're not saying that that's improper argument. We're saying that it doubled down on the harm, because that was a big part of their defense in this case, is that everybody knows about these 4 pieces of our invention. And so since everybody knows about them, it can't be a trade secret. And this instruction, the first part of it says a combination of known elements can be a trade secret. And then at their Drillquip's instance, the judge added this sentence and said, except that, the whole has to be greater than the parts. Well, again, it's erroneous as a matter of law. Charge error is very dangerous, and changing the charge at this point and emphasizing it to the jury created harm.
Sorry, we're probably all going to ask
I
this
know.
question. So what case or law would you direct us to that supports arguing that the combination instruction is not a correct statement of the law?
Well, the fact that we don't just make up stuff and put it in the jury charge, and there is no case that says what they say, and the cases that we have cited in our brief, and I'll get you the page numbers on rebuttal, talk about, they don't address that instruction directly, of course, because nobody's ever tried to give it. What they do is say that it doesn't matter if all these things are known, the combination can be a trade secret, period. It doesn't say, but it has to be worth more than the sum of the parts. So back to Mr. Pooley for a minute.
And can you remind,
yes.
Was there no opportunity to object to that?
To the charge?
Right, to that,
we
that
did.
particular
We did
sentence.
object to it. We objected to it the day before when it looked like the judge was going to put it in. Then he left it out, and so, you know, at the end of the time when he read the charge, Real Quick asked me to put it back in, and we had a lengthy discussion on the record about that, and, you know,
Well-
yes.
I mean, I take a little bit of issue with that description of what happened, because it seemed pretty clear from the record that both sides noticed that the judge had inadvertently pulled back up the charge that had been edited. And it looked like both sides noticed, oh, you know, I think maybe Mr. Ahmad said something about, you know, there's a blank missing here, and then the other side, sorry, I don't know, I don't remember everybody's names. It might have been Mr. Reasoner, noticed that, you know, that instruction that it appeared had been clearly ruled on the day before was missing. I mean, I'm not saying it went down in any kind of ideal way.